The hour of 10 o'clock having arrived, the meeting of the Pennsylvania Gaming Control Board will come to order. Good morning, everyone. I'm Dante Santoni, one of the commissioners of the Pennsylvania Gaming Control Board. Chairman Barish is unable to attend today's meeting, so I'll be leading the proceedings in his absence. If you haven't already, I would ask you to please turn off or at least put on silent your cell phones or any other electronic devices. Thank you. Along with my fellow commissioners, with us today are Fred Strathmeyer, representing Russell Redding, Secretary for the Department of Agriculture, Jennifer Langen, representing Joseph Torsella, State Treasurer, and Kristen Heidingsfelter, representing the Secretary for the Department of Revenue, Dan Hassel. Thank you all for coming and good morning. A quorum of the board members being present, I will officially call today's proceedings to order. First order of business, I would ask you to please rise for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. By way of announcements, the board held an executive session yesterday, Tuesday, January the 14th, to discuss personnel matters and to conduct quasi-judicial deliberations relating to matters coming before the board. I would also like to announce for the final time that the Local Law Enforcement Grant Program under Section 1408 of the Act is being re-implemented this fiscal year. We have posted on our website updated guidelines for local law enforcement agencies to apply for grants to combat illegal gambling. The date by which the local law enforcement agencies will need to apply for the grant is January the 21st, 2020. First order of business today, we'll have an oral argument regarding Fastball Holding LLC's petition for a board order seeking a waiver of licensure for some upstream companies as it relates to interactive gaming. These waivers have already been granted relative to sports wagering operations. Fastball Holdings, with a 37% interest, is a minority shareholder in Betfair Interactive US LLC, which has an agreement to conduct iGaming on behalf of the Valley Forge Casino Resort. As the parties agree with all the material facts in this matter, and the board is aware of these facts, we will be only conducting oral arguments today. May we have counsel for Fastball and OEC come forward, please. Before we begin, I would ask the counsel state and spell your name for the court reporter prior to your presentation.
Good morning, Commissioners. Frank DiGiacomo, D-I-G-I-A-C-O-M-O, from Duane Morris on behalf of the petitioner Fastball Holdings.
Good morning, Commissioner. Samantha Haggerty on behalf of petitioner Fastball Holdings, H-A-G-G-E-R-T-Y, from Duane Morris as well.
Okay, thank you. Petitioners, you may begin.
Thank you. As you noted, Commissioner Santoni, Fastball Holdings is currently a principal affiliate in connection with the licensee Betfair Interactive US. And as you also noted, in previously this board, actually in June, granted waivers of qualifications with respect to certain upstream entities, specifically affiliates of Comcast Corporation, two entities, Comcast Sports Ventures, LP, and NBC Sports Ventures, both of which have filed affiliate license applications. In addition, those entities include Capital G, which is a subsidiary of Alphabet, formerly Google, and other related entities. So the crux of our argument is what you noted, that this board previously determined that those entities did not have a controlling interest as defined in the Act, specifically that they met the burden and rebutted the burden by clear and convincing evidence of having the ability to control the applicant Betfair. We provided certifications as to the passivity of those investors. There are limitations in the structure. As you noted, Fastball holds only 37% of Betfair Interactive. There's no involvement with at Fastball level with respect to the operations of Betfair, either with respect to sports wagering or interactive gaming. Nothing has changed with respect to those companies. They all still involved. The shareholder percentages remain the same. It's the same companies that this board has granted waivers for with respect to the sports wagering license application. So there is a board seat, and one of the responses that OEC noted, Comcast Ventures and NBC Sports Ventures, they do hold a seat on the Fastball board, and that individual, Andrew Cleland, has filed for, he's a principal licensee with the board and has filed applications. I would note this, that board does not have operational control of Betfair in any way. Fastball is an entity that was created as part of the merger from FanDuel into Betfair, and Fastball shareholders are the legacy FanDuel shareholders, and as such, they have no operational control of the entity in any way, and really that board seat's there in the case of a situation where there's a buyout or a transaction where the entity is sold or the Fastball entity is divested. So the board seat role is just in the event if there's a fundamental change in the ownership structure, and really just to have some role in that fundamental change, but not on an operational level in any way as a traditional board seat would hold. So if there's any questions, certainly free.
We'll get to that in a second, but I think at this point, the Enforcement Council will hear from you now.
Thank you, Commissioner, and good morning to the other members of the board. It's Michael Rowland, ROL A&D with the Office of Enforcement Counsel. And by way of background again, Betfair Interactive US LLC is an applicant for an interactive gaming operator license and is presently seeking to offer internet wagering in conjunction with Valley Forge Convention Center Partners LLC, who's doing business as Valley Forge Casino Resort. Fastball Holdings LLC is a principal affiliate of Betfair and, as stated, owns approximately 37% of the equity interest in Betfair. As a result, Fastball has filed a principal affiliate application with the board. Capital G 2015 LP, Comcast Ventures LP, and NBC Sports Ventures LP are investors in Fastball and each have an ownership interest in Betfair. After reviewing these investor companies, along with the parent companies of each and several affiliated companies, the Bureau of Licensing determined that in addition to the 3 investor companies, 9 additional entities were required applicants for Betfair to conduct interactive gaming in Pennsylvania. Those entities included Comcast CVLP, Comcast Holdings Corporation, Comcast Corporation, NBC Universal Media LLC, NBC Universal LLC, and NBC Universal Enterprise Inc., DHC, all of which essentially make up NBC and its parent Comcast. And then the 3 remaining entities are Alphabet Holdings LLC, 26 Holdings Inc., and Alphabet Inc., all of which are essentially Google. After receiving the Bureau of Licensing's request for applications, Fastball filed the instant petition before you today, seeking waiver of the qualification requirements for the 6 Comcast entities and the 3 Google entities identified. And it should be noted, I believe it previously was, that on June 12, 2019, the board granted waivers for these 9 entities in conjunction with Betfair's application for a sports wagering license. The Office of Enforcement Counsel is of the opinion that the applicant made a conscious decision to enter the strictly regulated world of interactive gaming and should be held subject to the same strict licensing standards of any company seeking to operate and offer similar types of gaming in a brick-and-mortar casino in the Commonwealth. In fact, oversight in the virtual world of interactive gaming, where there's no face-to-face or physical interaction with individuals, and identifications are made by names, accounts, and locations, should be equally, if not more strict. Interactive gaming, as set forth in the Act, is similar to traditional casino gaming, but operates in a virtual or online platform. Like its brick-and-mortar counterparts, interactive gaming is subject to regulation and policing of all its activities in order to protect the public. An interactive gaming licensee can offer the same games to the general public that a brick-and-mortar casino can offer. Therefore, online games offered by interactive gaming licensees can include slots, blackjack, baccarat, craps, roulette, and poker, just to name a few. Sports wagering, whether it's retail sports wagering or online sports wagering, is not analogous to interactive slots, table games, and poker. Interactive sports wagering is significantly more focused and limited than interactive slots, table games, and poker, in that it's restricted to sporting events or the individual performance statistics of athletes. Sports wagering is a small fraction of gaming revenue in this Commonwealth. OEC is of the opinion, in light of the existing statutory and regulatory language, that interactive gaming is essentially the infancy of internet-available casinos in the Commonwealth, and applicants should be held to the same strict licensing standards, more in line with that of brick-and-mortar casinos, which offer similar types of gaming. Therefore, the Comcast and Google entities identified by the Bureau of Licensing should be subject to the same licensure under board's current regulation and regulatory standards. Almost daily, there is news of Comcast or Google gathering information on individuals who utilize its services. In fact, there have been congressional hearings regarding both companies. However, when Comcast and Google seek the privilege of participating in the Commonwealth's gaming industry, they point to SEC filings or other federal regulatory bodies and refuse to provide the same information required of other gaming-related companies operating in the Commonwealth. However, with that said, OEC is also of the opinion that other factors need to be considered before a final determination can be made, and that if the board is inclined to grant the requested waivers in this matter, OEC recommends that the board order and adopt regulation changes in this regard. OEC is of the opinion that entities should not be licensed just for the sake of licensing, and a significant or compelling reason should exist for the licensure of federally regulated, publicly traded companies that make passive or even semi-passive investments in the Commonwealth's gaming industry. Moving forward, OEC believes that meaningful pointed regulatory standards in such instances should be drafted and considered for adoption by the board to spur investment in the Commonwealth's gaming industry without sacrificing oversight. The regulatory standards should provide for some type of review and approval by a board designee in order to alleviate the need for filing waiver petitions in such instances. On a statutory level, Section 1311E and F of the Act allows for waiver of licensing requirements related to slot machine licenses. Slot machine licenses are arguably the core of gaming in the Commonwealth, since they were the starting point for our licensing. Section E provides that the board may waive licensing requirements for a person directly or indirectly holding an ownership of securities in a publicly traded corporation if the board determines that the holder of the securities is not significantly involved in the activities of the corporation and does not have the ability to control the corporation or elect one or more directors. Section F provides waivers for subsidiaries, it's primarily holding companies and intermediaries. Under Section F, if the applicant is a publicly traded corporation, the board may issue a waiver if it determines that the principal or key employee does not have the ability to control, have a controlling interest in, or elect one or more directors of the holding company or intermediary, and is not actively involved in the activities of the applicant. If the applicant is a non-corporate organization, the board may issue a waiver for a person who directly or indirectly holds a beneficial or ownership interest in the applicant if it deems the board does not have the ability to control the applicant. This statutory language, coupled with the great discretion given to the board throughout the act, should allow for meaningful regulatory changes in this area. In fact, the Bureau of Licensing provided an alternative, which has been incorporated in our responsive pleadings. However, the Office of Enforcement Counsel believes that substantial regulation changes should be made in this area to ensure ongoing integrity, consistency, and efficiency in order to adapt to the constant changing gaming environment in the Commonwealth. Since OEC is of the opinion that interactive gaming applicants should be held to the same licensing standards consistent with that of traditional casinos, which offer similar types of gaming, it seems only appropriate that the same considerations and waivers should be made available to those interactive gaming applicants. In fact, for purposes of consistency and simplicity, the same considerations and waivers should be applied to licenses across the board. The Office of Enforcement Counsel believes that waivers in this situation could be accomplished by way of staff review through the appropriate board designee with appropriate checks and balances created by regulations which are adopted by the board. OEC believes that by adopting equitable and updated licensing regulatory standards where possible, regarding passive or semi-passive investments made by publicly traded companies, the result would increase and spur future investments in the Commonwealth's gaming industry without sacrificing strict regulatory standards. As a result, the Office of Enforcement Counsel has proposed several conditions to implement should the board choose to grant application waivers in this matter. To be clear, and so that the point isn't taken out of our pleadings, gets lost in translation, we're not advocating the position that publicly traded companies should be considered institutional investors. We're advocating the use of institutional investor and foreign institutional investor requirements to serve as a potential framework when crafting or creating regulatory standards for publicly traded companies. As a result, any conditions in this regard should only serve as a placeholder until meaningful regulatory changes are adopted. Therefore, in conclusion, the Office of Enforcement Counsel respectfully requests that the board require that the 9 principal entities additionally identified by the Bureau of Licensing as set forth in its September 25th, 2019 letter to the applicant be subject to the present-day licensing requirements. However, in the alternative, should the board grant the relief sought by Fastball Holdings LLC regarding waiver of the qualification requirements of those entities, the Office of Enforcement Counsel requests that the relief be made subject to the 6 conditions set forth in OEC's December 17th, 2019 answer. Finally, it's respectfully requested that the board issue a directive in its order to initiate regulatory changes in this regard. The Office of Enforcement Counsel is available for any questions you might have. Thank you.
Thank you. The Fastball Holding have anything to add?
Yes, Commissioner. With respect to the latter point, Fastball and Comcast certainly are receptive to any regulatory modification that gives staff or this board more discretion to grant waivers. I think that is just sound regulatory principles, allows the staff to view each situation on its own merits and to recommend waivers and to have that enhanced flexibility. We certainly support that. With respect to the more specific arguments, the Comcast and Google invested in a company called FanDuel when it was a fantasy sports company, right? They did not enter the gaming industry with their eyes wide open. What happened after the Supreme Court decision where FanDuel repositioned itself as a sports wagering company, and then the subsequent merger with Betfair, that foisted upon those regulatory obligations onto Comcast and Google. Both are passive investors. They were passive investors in FanDuel, and they remain passive investors. OEC referenced the fact that both those entities, in their other roles, gather information They do, but they have no active role whatsoever in Betfair Interactive or FanDuel. They are passive investors. And that was the basis for the initial waiver petition. We submitted certifications as to that passivity. Although the board seat is at a holding company level, it is not an operational board seat. There's no ability to control operations, to make decisions as to what jurisdictions Betfair enters into, whether that's Pennsylvania or any other jurisdiction. We played no role whatsoever into the company's decision to enter into, to file an application for interactive gaming license. We are along for the ride and are trying to accommodate the regulators in every and have accommodated. I mean, we've put an individual up for licensure. We have filed for two in Comcast situation for 2 entities have filed applications with the Bureau of Licensing. It's just those entities above, all the way up to the publicly traded entity for which we are seeking waiver. Entities that have no involvement whatsoever even in this investment, entities that are just part of a large corporate structure that has been in place for a lot of different reasons for a number of years. So with respect to the distinction between sports wagering and iGaming, the Act makes no distinction. It creates this license level of principle, whether or not you are involved in sports wagering, interactive gaming, casino gaming. We have sought a waiver. This board granted a waiver for those entities from that level of licensure because we met the burden that we have no controlling interest. OEC is effectively asking for some bifurcated level of licensure here with respect to sports wagering and interactive gaming, a bifurcation that's not anywhere in the Act or the regulations. And we're just asking this board to be consistent with its prior ruling and grant a consistent ruling with respect to this license application as well.
Anything else from OEC?
Nothing additional, thank you.
Any questions or comments from the board? Okay, hearing none, thank you all. The board will consider this petition later in the meeting under the Office of Chief Counsel's portion of the agenda. What we're going to do now is get through the administrative portion of the agenda, take a short break, and the board will convene an executive session to deliberate on the fastball holdings, and then when we return, we'll do the rest of the agenda. Yes?
We also had the motion for confidentiality, and I didn't address that, but
So
that
moved.
remains. Thank you.
Thank you.
Thank you.
Thanks. Thank you.
Okay, next we have a consideration of a motion to approve the minutes and transcript of the November 20th, 2019 meeting. May I have a motion?
Mr. Chairman, I move that the board approve the minutes and transcript of the November 20th, 2019 meeting.
So, second.
All in favor?
Aye.
All opposed? The motion carries. At this time, next up, Executive Director Kevin O'Toole. Kevin?
Good morning, Commissioners. For my Executive Director's report this morning, I would like to give a brief overview of the performance of the Pennsylvania casino industry for calendar year 2019 from a revenue perspective. And I will also comment on the contribution of expanded gambling initiatives to those results. First, Pennsylvania's 12 operating casinos increased its total gaming revenues for 2019 from slot machines and table games by approximately $18 million when compared to calendar year 2018. The 2019 total for slots and table games revenue amounted to $3.267 billion, and that places 2019 as the highest revenue year for slots and table games at the Pennsylvania casinos, noting that 2018 was the previous high mark. Gambling expansion initiatives, which include sports wagering, interactive gaming for slots, table games, and poker, video gaming terminals operating at eligible truck stops, and fantasy sports contests, have contributed approximately $144 million to the combined revenues from all types of activity regulated by the Gaming Control Board. That combined revenue figure for all types of activity regulated by the board is approximately $3.41 billion for calendar year 2019. Additionally, tax revenue to the Commonwealth, along with local share assessments, have totaled approximately $1.41 billion for calendar year 2019. So clearly, that's a good picture for the past year. And it's most important to recognize that the management teams at our casinos, as well as those teams with the online operators and manufacturers who have entered our jurisdiction over the past several years to work in partnership with the casino operators, have all worked very hard to deliver the best gaming products in Pennsylvania and to Pennsylvanians. And these revenue figures clearly reflect the success of their efforts. Thank you, Commissioner.
Thank you, Kevin. Any questions or comments? Okay. Good news. We're doing pretty well. It's good to hear. Next up, we have Personnel Matters with Danette Bixler-George, Director of Human Resources. Good morning.
Good morning, Commissioners. The Office of Human Resources has one motion for your consideration today relative to the hiring of 2 individuals. Both of these individuals have completed the interview process, background investigations, and drug screening. First is Kyler Kunstler, who has been selected as a technical field representative at Mount Airy Casino in the Bureau of Casino Compliance, and he is recommended for hire by Christopher Schroeder, who is the Bureau Director for Casino Compliance. Second is Travis Foddy, who has been selected as a licensing analyst in the Employee Permitting Unit in the Bureau of Licensing and is recommended for hire by Susan Hensel, Bureau Director for Licensing. Unless you have questions, I ask the board consider a motion to approve the hiring actions as indicated.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board approve the applicants for hire as proposed by the Human Resource Director.
Second.
All in favor? Aye. All opposed? The motion carries.
Thank you.
Thank you, Danette. Next up, Director of Financial Management, Dave Wren. Good morning, Dave.
Good morning. I'm here today to present the board's budget status through the end of the second quarter of the fiscal year. The current year appropriation is $46,067,000. Overall, we are within budget and currently projecting a surplus as we assumed casino openings in the current year budget requests, which will not occur until next fiscal year. Overall, first half expenses were $17.6 million. This is up $302,000 or 1.6% from the same period last year. The increase is a result of higher personnel expenses due to salary increases and higher complement levels this year. The field complement stood at 302 employees at the conclusion of the quarter. Personnel expenses for the first half of the year were $17.6 million, up 4.3%. Personnel expenses account for 89% of the board's overall expenses for the first half of the year. Approximately 60% of personnel expenses were for salaries and the remaining 40% for benefits. Operating and fixed asset expenditures combined totaled $2.1 million, or 11% of all costs. This is down $70,000 from the same period last year, primarily due to timing differences. The leading operating expenditures were for services at $981,000, rentals and leases at $661,000, and travel at $160,000. That concludes my remarks.
Okay, any questions or comments from the board? Okay, thank you, Dave.
Thank you.
As I indicated earlier, we're going to take a 10-minute break to go into executive session to discuss the Fastball Holdings matter. Thank you. Meeting back. Chief Counsel Doug Sherman. Doug?
Good morning, Chairman, or Acting Chairman and Commissioners. Our first agenda item relates to final omitted regulation, which Assistant Chief Counsel Chad Zimmerman is here to present.
Good morning, Commissioners. Before you is a revised version of final omitted regulation number 125-228 pertaining to the table game rules of play general provisions. This was previously before the board in its original format on November 20th of 2019 at a meeting where the board adopted the original regulation package. After all copies were delivered to the necessary parties, there were a few meetings held on the subject matter of the regulations and the amendments to the procedures for the approval of table games in the Commonwealth and the publication of the rules thereto. After those meetings, the Office of Chief Counsel received a tolling memo from the Attorney General's office requesting some clarifications and recommending some changes to the regulation package to provide some clarity on the procedures. Those matters were addressed in this revised regulatory package, and we are submitting it again today for your consideration. And if I can answer any questions, if there are none, then I would request a motion to adopt the revised final omitted rulemaking number 125-228.
Are there any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt final omitted regulation number 125-228 regarding amendments to general table game provisions as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion carries.
Thank you.
Next, the board has 4 petitions before it for consideration. One of these matters was heard just a short time ago during oral argument. The second petition was heard by the board in January of 2019 and was tabled at that time and now is being presented for a vote. And the remaining 2 matters will be decided upon the documentary records by agreement of the parties. In each of these 4 matters, however, all of the record filed has been provided to the board in advance of this meeting. That first matter before the board is Fastball Holdings, LLC's request for a board order waiving the qualification requirement for certain upstream entities. The board heard oral argument on this matter, as I had indicated, and it's ready for the board's consideration.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant Fastball Holdings LLC petition for a board order waiving the qualification requirement of certain entities with the conditions which will be outlined in the board's order. I further move that petitioner's motion for confidentiality be granted.
Second.
All in favor?
Aye.
Opposed? The motion carries.
Woodlands Fayette LLC is the next petition before the board today, and they are requesting the surrender of the principal license of Joseph A. Hardy III, the founder of Nemacolin Woodlands. The board heard oral argument in this matter at a prior meeting and is now ready for the board's vote. By way of background, in 2001, Woodlands was conveyed by Mr. Hardy as grantor of an irrevocable trust for the benefit of his daughter. In creating the trust, Mr. Hardy waived any and all rights to property placed in it and income derived from it. Moreover, Mr. Hardy has no control over the trust and any of the properties owned by the trust. As the grantor of the property which holds the casino license, Mr. Hardy was required by the Gaming Act to obtain a principal license. He did this, and his current license is set to expire in September 2020, which would mean that he'd have to file a renewal application approximately 60 days from today if he's required to retain the principal license. Woodland's petition requests that Mr. Hardy be allowed to surrender his principal license and that he not be required to file any further applications. They argue that the trust is irrevocable and Mr. Hardy has no control over its assets and receives no benefits therefrom, and that therefore there's no reason to continue to have him licensed and be found suitable after he no longer has any control. The Office of Enforcement Counsel has disagreed with that position and argued that a strict reading of the act states that the grantor of the trust shall be licensed as a principal and does not address this situation specifically, and therefore they counsel that the license should be continued. As indicated, the board heard oral argument about a year ago on this matter. You have all the documents that have been filed of record, and it's ready for the board's consideration.
Any questions or comments from the board? May I have a motion?
I move that the board grant a petition of Woodlands Fayette LLC to surrender the license of Joseph A. Hardy III, given the specific circumstances of this case and with the conditions to be outlined in the board's order. I further move that the request for confidentiality be granted.
Second.
All in favor?
Aye.
Opposed? The motion carries.
JOSC LLC's petition for removal from the board's prohibited gaming service provider list is the next matter before the board. In June of 2008, JOSC submitted a certified vendor application under the regulatory scheme that was in place at that time. Between December 2008 and February 2009, the Bureau of Investigation and Enforcement reached out to JOSC requesting information needed to proceed with the application and the investigation process. JOSC initially failed to provide the requested information, and subsequently the Office of Enforcement Counsel sent them a failure to cooperate letter. JOSC eventually provided the requested materials, and in May of 2010, the board granted JOSC the certification, subject to the condition that they pay a $4,000 certification fee and a little over $4,100 in outstanding investigative fees. However, JOSC failed to pay the fees despite their obligation, and in August 2011, the board placed them on the prohibited gaming service provider list. During the pendency of the matter, JOSC provided services to the gaming industry as a subcontractor to another gaming service provider. Now, 8.5 years later, JOSC has requested to be removed from the list. OEC has no objection to the request, provided that JOSC pay the sum of $8,134.51, which was the certification fee and the outstanding investigative cost, that they also pay a $1,500 administrative fee to pay for the board's and staff's cost in responding to this matter. However, I note that the board has broad discretion in determining whether to grant the relief or not. And therefore, subject to that discretion, the matter is now ready for the board's consideration.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant JOSC LLC's petition for removal from the prohibited gaming service provider list as described by the Office of Chief Counsel with the conditions requested by Enforcement Counsel and payment of 6% annual interest on all past due amounts.
Second.
All in favor?
Aye.
All opposed? The motion carries.
Okay. The final petition before the board today is Andrew Fisher's request for removal from the board's involuntary exclusion list. On May 7th, 2016, Mr. Fisher, who was 18 years old at the time, entered Sugar House Casino by providing a false identification to security. He was on the gaming floor for about an hour in which he wagered and had an alcoholic beverage. When found, he was charged with a summary offense and evicted from Sugar House. On April 26th of 2017, subsequent to an OEC petition to exclude, this board placed Mr. Fisher on the exclusion list until at least his 22nd birthday, at which time he could request to be removed from the list. Mr. Fisher is now 22 years of age and has requested removal from the exclusion list. OEC has no objection to the request, and that matter is now appropriate for the board's motion.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board grants Andrew Fisher's petition for removal from the PGCB involuntary exclusion list described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion carries.
Okay. Next, presenting withdrawals and reports and recommendations is Deputy Chief Counsel Steve Cook.
Morning. The board has received several unopposed petitions to surrender the credentials or withdraw the applications of the following individuals or businesses: Joseph Bertolone, Eric Neiman, Rutter's store number 5 in Fayetteville, PA, and Rutter's store number 70 in Strasburg, PA. Matthew Katz, Sarah Craven, Ronald Cushy, Anthony G. Wooten, and Christopher DeRossi. The Office of Enforcement Counsel has no objection to any of these requests for withdrawal or surrender, and as a result, if the board were inclined to grant these requests, they'd be doing so without prejudice to each of these parties, and the matter is now ready for the board's consideration.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue orders to approve the withdrawals and surrenders as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
Opposed? The motion carries.
Next before the board for consideration are 3 reports and recommendations received from the Office of Hearings and Appeals. The board has been provided with the materials, the report and recommendation and the underlying evidentiary materials prior to today's meeting. And additionally, the person that is the subject of each of these reports and recommendations have been notified that the board would be taking the matter up today and that they could come forward and briefly address the board before a vote. If any of these persons are present and wish to address the board, I'd ask them to come forward when their matter is called. The first matter to be heard by the board is the report and recommendation regarding Jian Chu Zhu. Briefly, in May of 2019, the board placed Mr. Zhu on the exclusion list after he failed to respond to an Office of Enforcement Counsel petition to place him on the exclusion list. OEC had requested that Mr. Zhu be placed on the list following an incident where a companion of his was observed posting bets at an empty seat at a Meadows Casino mini baccarat table, and Mr. Zhu thereafter sat at what was the empty seat and collected his companion's unlawful winnings. After receiving the order placing him on the list through default judgment, Mr. Zhu filed a request for reconsideration on May 20th, 2019. The board thereafter granted this request, removed him from the list, and referred the matter to Hearings and Appeals for a hearing. That hearing occurred on August 29th, 2019. At the hearing, OEC appeared presenting testimony and documentary and video evidence. Mr. Zhu also attended the hearing and testified on his own behalf. Mr. Zhu ultimately testified to slightly different facts, but ultimately acknowledged that on the night in question, he did collect monies from the casino that he was not entitled, to which he was not entitled. And after hearing that evidence, as well as all of the evidence presented by OEC, the hearing officer issued his report and recommendation, which recommends that Mr. Zhu be placed on the exclusion list, and that's the recommendation for the board's consideration.
Okay. Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding the placement of Jian Chu Zhu on the PGCB involuntary exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion carries.
The next report and recommendation before the board pertains to AN's request for removal from the voluntary self-exclusion list. A hearing was held in this matter on September 26, 2019. The Office of Enforcement Counsel appeared presenting testimony and documentary evidence. Despite receiving proper notice, AN failed to attend that hearing and it proceeded in his absence. Pursuant to the uncontested findings of fact, the report and recommendation issued in this matter states that on February 7th, 2013, AN entered Parks Casino, met with the casino compliance representative, and requested to be placed on the lifetime self-exclusion list. The casino compliance representative testified that he went through the process with AN and completed all the appropriate paperwork. At the hearing, there was also testimony of employee staff from the board's Office of Compulsive and Problem Gaming indicated that this past March of 2019, AN contacted the Office of Compulsive and Problem Gambling, indicating that he continued to have a gambling problem and looking for information as to where he might be able to go for treatment. That was in fact provided to him by our staff. However, 3 months after that request, in June of 2019, AN filed the request that's now before the board, in which he indicated that essentially he did not have a gambling problem and he wished to be removed from the list. The Office of Enforcement Counsel filed its answer objecting to that request, which led to the hearing and the evidence I just discussed. After hearing all of this evidence, the hearing officer recommends that AN, in fact, remain on the board's self-exclusion list.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding AN's petition for removal from the PGCB voluntary self-exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion carries.
The final report and recommendation before the board today pertains to another request for removal from the voluntary self-exclusion list. Specifically, on June 10th, 2016, an individual with the initials MB entered Mohegan Sun at Pocono Downs Casino and requested to be placed on the self-exclusion list. The casino compliance representative who placed MB on the list testified that he conducted the mandatory interview, explained the process of being placed on the list, the consequences of the various periods of time one could choose to be placed on the list, and the casino compliance representative also testified that MB knowingly fulfilled or went through the process with him and signed an acknowledgement form selecting lifetime self-exclusion. Approximately 3 years later, on April 29th of 2019, MB filed a request for removal from the lifetime self-exclusion list, and the Office of Enforcement Counsel responded objecting to that request. A hearing was held on August 8th, 2019. Both OEC with witnesses and MB appeared and presented evidence. Specifically, MB testified that he understood what he was doing when he placed himself on the list 3 years earlier. However, he indicated that his circumstances at the time were that he had just lost his father. He was in mourning and thought it was the best thing for him to do to be placed on the list at that time. But unfortunately for him, he chose lifetime as opposed to a 1-year or a 5-year term. Ultimately, he indicated that he's in a much better place now, would like to remove himself from the list so he can get back to the casinos with his daughter and his girlfriend. Hearing all the evidence, the report and recommendation issued in this matter by the hearing officer recommends that since MB chose the lifetime self-exclusion list, that in fact he remain on the list since only 3 years has passed since his placement, and that's the recommendation before the board.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding MB's petition for removal from the PGCB voluntary self-exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
Opposed? The motion carries.
And that concludes the matters of the Office of Chief
Thank you,
Counsel.
Doug and Steve. Next up, we have the Bureau of Licensing Matters with Director Susan Hensel. Good morning, Susan.
Thank you. Thank you, Commissioners. Before the board today will be the licenses for one slot machine manufacturer designee, one video gaming terminal procurement agent, one conditional sports wagering operator, and 6 conditional video gaming terminal establishments. In addition, there will be 926 key gaming and non-gaming employee applicants. Finally, there will be the consideration of 2 certified and 8 registered gaming service provider applicants. The first matter for your consideration is renewal of a slot machine manufacturer designee license for NRT Technologies, Inc., which is headquartered in Nevada. NRT Technologies, Inc. has been designated to provide sales and technical support to licensed slot machine manufacturer NRT Technology Corp. Bureau of Investigations and Enforcement has completed its investigation of NRT Technologies, Inc., and the Bureau of Licensing has provided you with a background investigation and suitability report. I have provided you with a draft order and ask that the board consider the order to approve the slot machine manufacturer designee renewal license.
Enforcement Counsel has no objection.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board grants NRT Technology, Inc. renewal for a slot machine manufacturing designee license as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Opposed? The motion carries.
The next matter is a license for VGT procurement agent applicant Bell Gaming LLC. Bell Gaming LLC is an Illinois-based business. It is currently conditionally licensed. A procurement agent negotiates terminal placement agreements on behalf of a VGT terminal operator for placement of VGTs in truck stop establishments. The Bureau of Investigations and Enforcement has completed its investigation, and the Bureau of Licensing has provided you with a background investigation and suitability report. I have provided you with a draft order and ask that you consider the order to license Bell Gaming LLC as a procurement agent.
Enforcement Counsel has no objection.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant Bell Gaming LLC's video gaming terminal procurement agent license as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Opposed? The motion carries.
Next is a conditional sports wagering operator license for Betfred Sports Pennsylvania LLC, doing business as Betfred Sports/Wind Creek Sports. Betfred Sports is located in Las Vegas, Nevada. It proposes to operate sports wagering on behalf of at least one sports wagering certificate holder. The board may issue a conditional sports wagering operator license, provided the applicant has submitted a completed application, agrees to pay the licensing fee prior to license issuance, and the Bureau of Investigations and Enforcement does not object to the license. The applicant satisfies these criteria. I ask that the board consider the order to conditionally license Betfred Sports Pennsylvania LLC as a sports wagering operator.
Enforcement Council has no objection.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant the conditional sports wagering operator license of Betfred Sports PA LLC, doing business as Betfred Sports Wind Creek Sports as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Opposed? The motion carries.
Additionally, for your consideration are conditional VGT establishment licenses. The board may conditionally license an establishment provided the applicant has never been convicted of a felony, is current on state taxes, has submitted a completed application, and has not been convicted of a gambling law violation. A preliminary review of these applicants indicates that they meet these criteria. However, final approval will be based on the applicants meeting all of the eligibility criteria provided in the statute. A final eligibility determination will follow investigation and site inspection by the Bureau of Investigations and Enforcement. The first set of establishment applicants are CHR Corporation, doing business as First Rutter's Store 20, located at 2800 Vine Street in Middletown, and second, Rutter's Street 77, located at 77 Benview Road in Duncannon. I ask that the board consider a motion approving the conditional establishment licenses for CHR Corporation, doing business as Rutter's Store 20 and 77.
Enforcement Council has no objection.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant the conditional video gaming terminal establishment licenses for CHR Corp. doing business as Rudder Store number 20 and Store number 77, as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Opposed? The motion carries.
The second set of applicants are Pilot Travel Centers LLC, doing business as Pilot Travel Centers 81, located at 2010 Newcastle Road in Portersville. Pilot Travel Centers number 707, located at 246 Allegheny Boulevard in Brookville. Pilot Travel Center 709, located at 5609 Nittany Valley Drive in Mill Hall. And Pilot Travel Center 710, located at 1623 Oliver Road in New Milford. I ask that the board consider a motion approving the Pilot Travel Centers LLC related conditional establishment licenses.
Enforcement Council has no objection.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board grants the conditional video game terminal establishment licenses for Pilot Travel Center LLC, doing business as Pilot Travel Center for locations number 081, number 707, number 709, and 710, as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Opposed? The motion carries.
Next is a one-year license extension for conditionally licensed video gaming terminal establishment CHR Corporation, doing business as Rudder Store 17. The company was granted a one-year conditional license approximately 1 year ago. Under the Gaming Act and board regulations, the board is authorized to extend the license for an additional 1 year for good cause. The background investigation and suitability report process for this company is continuing. I ask that the board consider the order granting the one-year extension to CHR Corp. Doing business as Rudder Store 17, located in East Berlin.
Enforcement Council has no objection.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant the conditional VGT establishment license extension for CHR Corp. doing business as Rutter's Store Number 17, as described by the Bureau of Licensing.
Second.
All in favor? Aye. Opposed? The motion carries.
In addition, there are temporary licenses for your consideration. Prior to this meeting, the Bureau of Licensing provided you with an order regarding the issuance of temporary licenses for 14 key employees. I ask that the board consider the order approving these licenses.
Enforcement Council has no objection.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant the temporary key employee credentials as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Opposed? The motion carries.
Also for your consideration are gaming permits and non-gaming registrations. Prior to this meeting, the Bureau of Licensing provided you with a list of 640 individuals to whom the Bureau has granted temporary or full occupation permits, and 182 individuals to whom the Bureau has granted registrations under the authority delegated to the Bureau of Licensing. I ask that the board consider a motion approving the order.
Enforcement Council has no objection.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant the gaming employee occupation permits and non-gaming employee registrations as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Opposed? The motion carries.
There are also recommendations of denial for 5 gaming employee applicants and 2 non-gaming employee applicants. The applicants were notified they were being recommended for denial and failed to request hearings within the specified time frame. The Bureau of Licensing has provided you with orders addressing each of these applicants, who the Office of Enforcement Counsel has recommended for denial. I ask that the board consider the orders approving these denials.
Enforcement Council continues to request denial in each instance.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board deny the gaming and non-gaming employee applications as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Opposed? The motion carries.
The next matters for your consideration are withdrawal requests. In each case, the permit or registration is no longer required. For today's meeting, I have provided the board with 66 gaming applicants and 17 non-gaming applicants. I ask that the board consider the order approving the withdrawals.
Enforcement Council has no objection.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board grants the withdrawal of gaming and non-gaming employee applicants as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Opposed? The motion carries.
Next, we have orders to renew the certifications of the following gaming service providers: Baldini Communications LLC and JPC Group, Inc. I ask that the board consider the order approving these gaming service providers for renewal certification.
Enforcement Council has no objection.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the applications for gaming service provider certification as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Opposed? The motion carries.
Finally, for your consideration are gaming service provider registrations. The Bureau of Licensing provided you with an order and an attached list of 8 registered gaming service provider applicants. I ask that the board consider the order registering these gaming service providers.
Enforcement Council has no objection.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the applications for gaming service provider registration as described by the Bureau of Licensing.
Second.
All in favor? Aye. Opposed? The motion carries.
That concludes the matters of the Bureau of Licensing.
Thank you, Susan. Next up, we'll hear from Chief Enforcement Counsel Cyrus Petrie.
Good morning. The Office of Enforcement Counsel will present 7 matters today for the board's consideration, in which we will request the board's approval of 1 consent agreement, 1 revocation, and 5 involuntary exclusions. Next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Category 1 licensee Mountain View Thoroughbred Racing Association, LLC, doing business as Hollywood Casino at Penn National Racecourse. The consent agreement will be presented by Assistant Enforcement Counsel Thomas Monahan. Representatives from Hollywood Casino are present, and at this time I request that those individuals introduce themselves for the record, and that anyone not here as an attorney please stand and be sworn.
You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Alex Vizda, ALEX HVIZDA.
Good morning, Commissioner. Good morning, Commissioner. Sorry, Dan Im, IHM. So thank you for having us. I'm going to.
I think we'll have OEC present first, and then we'll have an opportunity to respond.
Thank you.
Okay.
Good morning, Thomas Monahan, MONAGHAN with the Office of Enforcement Counsel. The next matter for the board's consideration is a consent agreement between Mountain View Thoroughbred Racing Association, LLC, doing business as Hollywood Casino, and the OEC regarding Hollywood conducting poker tournaments that were not approved by the Pennsylvania Gaming Control Board. On or about September 13th, 2019, Hollywood's Director of Compliance self-reported incidents to the Borough of Casino Compliance regarding Hollywood conducting 4 poker tournaments that were not approved by the PGCB. The first poker tournament was a Labor Day Classic poker tournament that was held on September 2nd, 2019. This tournament was never submitted to nor approved by PGCB. The 3 other poker tournaments were approved by the PGCB as daily Tuesday, Wednesday, and Thursday $80 no-limit tournaments. However, Hollywood conducted those 3 tournaments as $120 no-limit tournaments. The 3 unapproved daily tournaments were held a total of 95 times from February 5th, 2019 to September 12th, 2019. After it was discovered that the 3 tournaments were being run as $120 no-limit tournaments, Hollywood's Director of Compliance instructed Hollywood personnel to return to the approved $80 no-limit threshold immediately. At this time, OEC requests that the board approve this consent agreement between the parties. The terms of the settlement include that within 5 days of the board's order approving this consent agreement, Hollywood Casino shall pay a civil penalty of $20,000 and an administrative fee in the amount of $2,500. If you have any questions, OEC is available at this time.
Okay, Mountain View, if you have anything to add, go ahead.
Thank you. Good morning again. I'll go ahead and turn it over to Alex now.
Okay.
Good morning. Just very briefly, regarding the Labor Day Classic Poker Tournament, it was merely just a oversight with some turnover in the poker room. The tournaments are normally sent to me to send into the Bureau of Gaming Ops, and the promotions are sent to marketing. With this tournament happened to be sent to marketing instead of to me. There's 116 participants. The admin fee to the state was $2,320. With regard to the other tournaments, our recurring weekly poker tournament submission that was approved by the board had these weeknight tournaments scheduled as $80 no limits. We had weekend 120 no limits approved, and the room basically just got confused with the schedule. The difference between an $80 and a $120 no limit is that it has a higher buy-in, which means a bigger prize pool and more money to the state with the admin fee. Subsequent to this, we went ahead and revised our recurring weekly poker tournament submission to make it 120s across the board because that's been pretty successful for us. That's all.
Okay. Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the consent agreement between the Office of Enforcement Counsel and Mountain View Thoroughbred Racing Association, LLC, as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
Opposed? The motion carries. Thank you.
Thank you.
Thanks.
Next matter on the agenda consists of an enforcement action in which the Office of Enforcement Counsel filed a complaint seeking the revocation of a non-gaming registration issued by the board to respondent Ismael Charlemagne. The complaint has been filed with the board's Office of Hearings and Appeal and properly served upon the respondent, who in turn failed to respond within 30 days as required by board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment and properly served the same upon the respondent. Therefore, the facts in each complaint are deemed admitted. All filed documents have been provided to the board, and the matter is presently ripe for the board's consideration. A brief summary of the facts and the request for the appropriate board action will be provided by Assistant Enforcement Counsel Thomas Monahan.
The next matter on the agenda for the board's consideration is the revocation of the non-gaming employee registration issued to Ismael Charlemagne. On April 28, 2019, Mr. Charlemagne redeemed a $75 voucher that belonged to a patron at Mount Airy Casino in an attempt to keep the money to which he was not entitled. Mr. Charlemagne was terminated for his actions. At this time, OEC requests that the board revoke the non-gaming employee registration issued to Ismael Charlemagne.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the revocation of Ismael Charlemagne's non-gaming employee registration as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
Opposed? The motion carries.
The remaining matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel filed petitions seeking the involuntary exclusion of individuals whose presence in a licensed facility are inimical to the interests of the Commonwealth and are licensed gaming therein. In each instance, a petition for exclusion has been filed filed with the Board's Office of Hearings and Appeal and properly served upon the individual named in the petition. The individual named in the petition failed to respond within 30 days as required by board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment in each instance and properly served the same upon each named individual. Therefore, all facts in each petition are deemed admitted. All filed documents have been provided to the board, and the matters are presently ripe for the board's consideration. In each instance, if the board orders a proposed exclusion, each individual's photo, personal identifiers, and a summary of their inimical conduct will be placed on the board's public website.
Good morning, Sarah Colasar, Kolesar, Assistant Enforcement Counsel for the Office of Enforcement Counsel. The following two matters on the agenda for the board's consideration are requests to place Maurice Bean and Takemia Kelly on the board's involuntary exclusion list. These requests arise from the same incident, and with the board's permission, I'd like to present one fact pattern that pertains to both individuals. Mr. Bean and Ms. Kelly left two children, ages 1-year-old and 3 years old, unattended in a vehicle in the parking lot at the Rivers Casino, Philadelphia. During this time, the couple went inside the casino for approximately 13 minutes, where they redeemed $33 worth of roulette chips for cash before returning to the vehicle. Accordingly, at this time, OEC requests that the board place Maurice Bean on the board's involuntary exclusion list.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approves the addition of Maurice Beans to the PGCB involuntary exclusion list described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
Opposed? The motion carries.
At this time, OEC requests that the board place Takemia Kelly on the board's involuntary exclusion list.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Takemia Kelly to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
Opposed? The motion carries.
Good morning, members of the board. John Crowe, CROHE, for the Office of Enforcement Counsel. The next matter on the agenda for the board's consideration is a petition for the placement of Ryan Terrell on the board's involuntary exclusion list. Mr. Terrell stole a purse containing $175 in cash, multiple credit cards, a security card, a social security card, and a Samsung cell phone from another patron while gaming at Mohegan Sun Pocono and fled from the facility. As a result, Mr. Terrell was permanently banned from Mohegan Sun Pocono and was charged with and pleaded guilty to theft by unlawful taking. At this time, the Office of Enforcement Counsel requests that the board place Ryan Terrell on the board's involuntary exclusion list.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Ryan Terrell to the PGCB involuntary exclusion list as described by the Office of Chief Counsel of Enforcement Counsel.
Second.
All in favor?
Aye.
Opposed? The motion carries.
The next matter on the agenda for the board's consideration is a petition for the placement of Jamar Kinder on the board's involuntary exclusion list. Mr. Kinder left his 2-year-old child unattended in a vehicle in the Harris parking garage for approximately 13 minutes while he entered Harris, cashed out a wagering ticket at the sports book, and ordered a drink at the bar. As a result, Mr. Kinder was issued a permanent eviction from Harris, and Mr. Kinder was criminally charged with endangering the welfare of a child and disorderly conduct. At this time, the Office of Enforcement Counsel requests that the board place Jamar Kinder on the board's involuntary exclusion list.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Jamar Kinder to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
Opposed? The motion carries.
The final matter on the agenda for the board's consideration is a petition for the placement of Sterling Brown on the board's involuntary exclusion list. Mr. Brown cheated on 2 occasions while playing blackjack at Harris, resulting in a win of $72.50 obtained by fraud. As a result, Mr. Brown was issued a permanent eviction from Harris, and Mr. Brown was criminally charged with knowingly by trick or fraud winning or reducing a loss. At this time, the Office of Enforcement Counsel requests that the board place Sterling Brown on the board's involuntary exclusion list.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Sterling Brown to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
Opposed? The motion carries.
Thank you. That concludes our business.
Thank you. That concludes today's meeting. Next public meeting will be held on Wednesday, February 12th at 10 a.m. in this room. May I have a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
The motion carries. The meeting is adjourned. Thank you, one and all.